2 weeks from today. Made an application seeking that the 2 respondents herein be detained at Kilimani Police Station for 10 days to enable number 96075 Corporal Dennis Mugambi complete investigations into offenses of obtaining money by false pretenses, contrary to section 313 of the Penal Code, and the offense of conspiracy to defraud, contrary to section 317 of the Penal Code. The same was premised on the grounds that the complainants had been defrauded $447,000 by persons pretending to be genuine gold dealers capable of exporting gold consignments from Kenya to Dubai. The application was supported by the affidavit of Corporal Dennis Mugambi. The prosecution submitted that the investigations have established movement of proceeds of crime through multiple cryptocurrency wallets associated with the respondents and other accomplices. In addition to that, during the arrest, the first respondent resisted arrest by locking herself at Crystal Villas house number 10, and owing to her conduct, there is a reasonable apprehension that she is a flight risk. The prosecution further submitted that the respondents had persistently evaded arrest until the IO got some intelligence information leading to the arrest. The prosecution submitted that the second respondent was willing to cooperate with the investigating officer and that other accomplices were still at large. The first respondent, through counsel, vehemently objected to the application seeking to detain her for a period of 10 days. Counsel submitted that the state had not provided compelling reasons to be granted 10 days. He submitted that at paragraph 7, the deponent, that is the IO Dennis Mugambi, had deponed that they had obtained other orders in miscellaneous E2143 of 2026, directed to Binana Holdings Limited, Nest Exchange Limited, Nest Clearing and Custody, and Nest Trading Limited for purposes of obtaining the KYC records linked to wallet accounts, transaction histories, access logs, and freezing of the identified wallets suspected to contain proceeds of crime. At paragraph 21 of the affidavit, counsel for the first respondent submitted that no material evidence had been provided to indicate how the respondents shall greatly jeopardize ongoing investigations, interfere with tracing and apprehension of accomplices, compromise recovery and preservation of electronic data and documentary evidence. Counsel relied on the case of Republic versus Dwight Sagaray, 2013, where Justice Korir held that the state must prove that there is likelihood of witness interference. Counsel for the first respondent further submitted that the respondent was a mother of 3. He furnished the court with 3 birth certificates of, I'll just deal with the initials, ALK, born on 29th of January 2013, AY, born on 5th of February 2016, and ZMT, born on 23rd of August 2023. In addition, counsel submitted that the first respondent was also expectant and submitted a medical report prepared by one Dr. Matthias Odera Akech, confirming the same. In addition, counsel submitted on the issue of resisting arrest. He submitted that the officers did not identify themselves and did not provide a search warrant to her. He further submitted that the first respondent was not at flight risk, as she was arrested in a place in her residence, that is at Crystal Villas house number 10. In addition to that, counsel submitted that the first respondent was also taking care of her mother, who was in critical condition, and they furnished a report prepared by one Dr. MP Okemo. The second respondent's counsel, Mr. Duane, submitted the suspect had been in custody for the past 3 days and there are no compelling reasons to have them detained for 10 days, and that the second respondent was willing to support the IO in investigations, and they sought to have favorable bond terms. Counsel submitted that the second respondent resides in Isili and is a taxi driver with no capability of interfering with witnesses, and in any event, the IO had obtained orders in miscellaneous E2143 of 2026. They submitted that the second respondent had suffered a back fracture, and they furnished a report which was prepared by Dr. Jocelyn Nyokabi of Bilal Medical Center. So the issue for determination is whether the state has provided compelling reasons to warrant the court to detain the respondents for a period of 10 days. Article 49(1)(g) and H provides as follows, and I'll quote, Article 49(1), an arrested person has the right, G, at the first court appearance to be charged or be informed of the reason for the detention, continuing or to be released, and H, to be released on bond or bail on reasonable conditions pending a charge or trial unless there are compelling reasons not to be released. End of quote. So what are compelling reasons? In the case of Donford Kabage Mwangi, High Court at Nyeri, criminal case number 8 of 2016, the court held that, and I will quote, a compelling reasons to deny release in this context is one that is weighty and persuades the court that the accused should not be released. End of quote. In the case of Republic versus Danstan Mgunya and another, the High Court at Mombasa, criminal case number 26 of 2008, it was held by Justice Mohammed Ibrahim, who is now deceased, that to deny bail, the prosecution must provide cogent evidence and not mere allegations. End of quote. The prosecution submitted that the first respondent had resisted arrest, and through her conduct, she was a flight risk. On the other hand, the first respondent's counsel submitted that the officers did not identify themselves, and she was apprehensive to open for them the said house. In the case of Job Kenyanya Musoni versus Republic, the High Court at Nairobi, criminal application number 399 of 2012, the court held that mere allegations that the accused was a flight risk do not suffice, as the prosecution ought to have substantiated its claim. End of quote. While accepting that the text of Article 49(1)(f) of the Constitution may in certain circumstances and context comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his or her continued detention through the state's application to have him, so held must satisfy the double test. As it was held in the High Court Criminal Revision number 208 of 2020, Sudi Oscar Kipchumba versus Republic, through the National Cohesion and Integration Commission, the Honorable Justice Professor Joel Ngugi, then a High Court judge and now a judge of the Court of Appeal, had held that for continued detention, the state must satisfy the double test. Number one, that is A, first, the state must persuade the court that it is acting in absolute good faith and the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. B, second, the state must demonstrate that the continued detention of the individual without a charge is the least restrictive action it can take in balancing the quadruple interests present in a potential criminal trial. That is, the rights of the arrested individual, the public interest, order and security, and the needs to preserve the integrity of the administration of justice, and the interest of the victims of crime where appropriate, end of quote. By virtue of Article 21, Sub-Article 1, and Article 259 of the Constitution, the courts must act to aggrandize, not to diminish, the personal liberties of arrested individuals in line with other three interests. Differently put, the state must demonstrate that there are compelling reasons to deny the pre-charge bail while balancing all factors within the complex permutation presented by this quadruple interest without rectifying or essentializing any, end of quote. So what is the standard of proof in order to satisfy the double test for the continued detention of the respondents? The standard of proof is on a balance of probabilities. The question here is whether the prosecution did, on a balance of probabilities, demonstrate compelling reasons to hold the respondents in custody for 10 days to enable them complete investigations. In his affidavit, the IO Corporal Dennis Mugambi deposed at paragraph 7 that he had obtained earlier orders in miscellaneous E2143 of 2023 to conduct his investigations. No material evidence has been placed to indicate how the respondents can interfere with investigations, taking into account that there is an order in force for the IO to conduct investigations. In addition, it's not in dispute that the first respondent was arrested at Crystal Villas, number 10, therefore implying that her place of abode is well known. On the first issue, I believe the officers in effecting the said arrest were acting in good faith as they had received a complaint as provided for under the law. On the second issue, as to whether the state has demonstrated that the continued detention of the respondent is the least restrictive action while balancing the rights of the arrested individual, the public interest, order and security, and the need to preserve integrity of the administration of justice and the interest of victims of crime where appropriate. I've taken into account the medical reports for the respondents submitted before the court, and also am guided by the High Court Miscellaneous Application number 213 of 2020, Chris Philip Obure versus Republic, where Justice Wakiaga held as follows, and I will quote, "The role of investigations lie with the executive, and unless specifically provided for, the Constitution and statute, in the Constitution and the statute, the judiciary plays a minimum role in assisting with investigations." In addition to that, in the High Court case number 44 of 2015, Republic versus Gerald Mutuku Nyalita and Jacqueline Mwende Kithome, Justice Moreithi held as follows, and I will quote, that there were less restrictive means of ensuring protection of witnesses if there was likelihood of interference, end of quote. Therefore, taking all the issues in totality, the upshot is that the application by the prosecution to seeking to have the respondents be held in custody for a period of 10 days is hereby rejected. Therefore, I will grant the respondents bond and/or bail in the following terms. The respondents are hereby granted bond of Kenya shillings 2 million plus one surety of a similar amount. Number two, so in the alternative, cash bail of Kenya shillings 200,000 plus two contact persons. The respondents to deposit their respective passports in court. And the last one is the respondents to report to the IO on a weekly basis, that is once a week, until the investigations are completed. Those are the orders of the court.